guys, welcome back to the One Room Schoolhouse, and we're going to talk today a little bit about the U.S. Supreme Court, because apparently that's a topic that people are talking about.
Yeah, I don't know what the deal is. People are all fixated on that suddenly.
Seems like something happened, right? Maybe not only obviously the passing of somebody, and not to belittle anything when it comes to the death of someone who was loved or a family member, whatever the case is. Certainly not meaning to make light of that situation. However, looking at all the conversation right now with the president appointing somebody and how does that work and should it work and should it wait for the next election, we thought let's just back up historically and let's talk about what the Supreme Court was supposed to do, how it was supposed to look, and why it's even contentious today. One of the things we have in our collection are lots of really cool artifacts from back in guys who were actually part of the original U.S. Supreme Court. This is a letter from John Jay, who was the original Supreme Court Chief Justice, and many other things we have from him as well.
And this is from John Jay as well. This is the Federalist Papers. So this is considered probably the best commentary ever on the Constitution. He's one of the authors of it. And that original court actually had 6 justices on it. The Constitution says that the president can appoint those justices once Congress tells how many. And Congress is the one who gets to set the number. So the original 6, 3 of the 6 actually were signers of the Constitution. We have this one right here. This is from John Rutledge, a signer of the Constitution on the original Supreme Court. This is John Blair, signer of the Constitution.
And this is James Wilson, who also signed the Constitution, but he also signed the Declaration, which he was one of only 6 guys who did that.
And by the way, these are the law books that he created, because while he's sitting on the Supreme Court, he started America's first law school. And these are the lectures he gave at that first law school. So cool guys.
So,
and 3 signed the Constitution and 3 ratified the Constitution. And John Jay was one of the ratifiers.
Yeah, and so what's interesting about this, right? So this is a letter back from John Jay, who was the original Supreme Court Chief Justice. He resigned that position after only being there a few years. George Washington was the guy that helps appoint him to get there. But after Washington's presidency, John Jay says, you know, I've really had enough. This was kind of fun, but I want to go back to New York where I can really be influential and really make a difference. So he goes back and gets involved in New York politics. And it's kind of crazy today to think that when you're in charge of the U.S. Supreme Court, you view that as a not very powerful or important position, but that's what John Jay thought.
Well, this kind of goes with it too. John Rutledge, who was one of those original justices, he signed the Constitution. He actually served as the 2nd Chief Justice on the Supreme Court, but not technically, because he never got confirmed, because the Supreme Court only met for 6 weeks a year. And when the Supreme Court met that year, Congress wasn't in session, so they never got to ratify him as the Chief Justice. So he served as Chief Justice, but it just wasn't a big deal.
So the Senate couldn't confirm. So he's like the honorary Chief Justice or something of that nature. Here's what's interesting, though, is one of the things even we've mentioned before is in the Federalist Papers, it identifies that the judiciary is beyond comparison the weakest branch. The judiciary was never viewed as something that was going to be able to be politically charged and motivated, that was going to have the power to sway things politically in America. They didn't have that power, and because of that, the justices who were assigned, it wasn't even thought to be politically motivated, even though when a president was in power, whatever political party the president's of, if you were in Congress and the president chose a justice or a lawyer, whoever the person might be, to sit and fill a seat on the U.S. Supreme Court, largely Congress kind of just said, okay, we approve, we accept, we go along with it. It wasn't that contentious, and it didn't take that long to get the Senate affirmation. Until the early 1900s, on average, it took a little less than 7 days for a justice to be appointed and confirmed. It wasn't really till the early 1900s when progressives started doing a lot more.
And by the way, the reason things were so simple at the beginning for the first century was you have a written Constitution. You can read it. You know exactly what it says. It doesn't matter what party you're from. When you read it, you took an oath to uphold what the Constitution says. And so party doesn't matter. So that's why it took about a week to get these guys confirmed. But the progressives came in and said, no, we believe in a living Constitution. We believe the judges can rewrite the Constitution. In that progressive era, Chief Justice Charles Evan Hughes said, we are under a Constitution, but the Constitution is what the judges say that it is. Well, that puts a whole lot more significant on who your justices are.
And this led to a lot more debates in the U.S. Senate in the confirmation process. So up to really up to the early 1900s, before that progressive era, it was less than a week to get somebody nominated and confirmed in the U.S. Senate. After the progressives start getting involved in changing that idea of the way we read the Constitution, then it actually ends up going more like a month of this confirmation process, because now there's a lot more debates in the Senate. There's a lot more happening. But even in the midst of debates of the Senate, generally people that were nominated by the president were confirmed. It really was more in the Reagan era when a lot of this changed. When up to that point, there still were a lot of debates over the validity that somebody might have and how good their credentials might be. But generally, they kind of acknowledged if that's what the president chose, we're going to go along with that position.
So with President Reagan, what you see is people like Judge Robert Bork, who got nominated for the Supreme Court. Now, he's on the D.C. Circuit Court of Appeals, which is a court directly below the Supreme Court.
Which means his credentials were very good.
Very good credentials.
For him to be there, he knows what he's doing. He's a qualified judge. And generally, when the president appoints somebody, the Senate might run them through the ringer. They might give them some trouble. It might be a difficult process, but you generally are going to confirm them. It didn't happen this way this time.
No, with Robert Bork, they spent so much time going after. This is the first really vicious confirmation that was there. And what you have at stake is Robert Bork is a constitutional conservative, and he's very clear. And the problem is, when you look back at Roe v. Wade, which has happened at that time, only just a decade or so earlier, that wasn't based on the Constitution. That was based on what judges wanted. Mm-hmm. And you back up a decade before that, and we've had prayer in schools and Bible in schools for 2 centuries, but those justices didn't want it. And if you have Robert Bork, he might reverse Roe v. Wade and allow prayer to be in schools again, and we can't have that. And so it was called borking. They borked Judge Bork, and after that, when they went after other judges and tried to keep them off the court, it was called borking them. And so that's where it really became political, and that's where you see the time it takes to confirm a judge move up into the 2-month era, because now you got to publicly vilify him in the media and publicly get people turned against him.
And this is also where it became much more political, because now we're recognizing the Supreme Court actually is doing legislation from the bench. And so we need to make sure that our political party is well represented on the Supreme Court so that our views can be enshrined in law because the U.S. Supreme Court said it was law. This now is no longer viewing the judicial branch of the U.S. Supreme Court the way the Constitution or the Federalist Papers or the Founding Fathers intended, because they're not interpreting law under the Constitution. They're now creating and establishing law in sometimes contrast or contrary to the Constitution. And so it became a much more powerfully viewed position and seat. And this is why now there's even greater levels of debate, which is why now, with a justice having passed away, there's great levels of contention and debate. And people are saying, wait a second, the president shouldn't do this because back in 2016, this was something Mitch McConnell said back then, is that the next president should decide. And people are saying, well, now he's being hypocritical, except conditions are a little bit different because back in 2016, President Obama was a different political party than the leader of the Senate. So the majority of the Senate was Republican and the president was Democrat, as opposed to this time when the president is Republican and the Senate's Republican. Things are a little different when your party is in charge, and that's true historically.
There's about 29 examples of where that as a president is getting in his last year of office, a Supreme Court justice leaves, dies, resigns, whatever, and he gets to appoint one. And so what happens is 17 times, or actually 19 times, when the president in power is of the same party as the Senate, 17 out of the 19 times, which is the way it is today, by the way. The Republicans hold the Senate, Republicans have the presidency. 17 of 19 times when the same party had the Senate and the presidency, 17 of the 19 times they went ahead and confirmed the justice. The times when the president was from one party and the Senate leader or the Senate was from another, which has happened on 10 occasions, which is what it was back with President Obama, 8 out of the 10 occasions, they did not confirm that justice. So if it's coming when the party is the same between the president and the Senate, 17 out of 19 they do, that's what this situation is.
And the president, in any occasion, has the authority to appoint somebody for the Senate to review, but the Senate can decide we don't want to review or we will review. And this is where, even today, the only reason there's as great a conversation as there is because the U.S. Supreme Court has so far overstepped the bounds of the power that they have that they're not supposed to have constitutionally. And actually, according to the Constitution, the Supreme Court can only do what Congress allows them to do because they can only hear the issues that Congress approves for them to hear. The Supreme Court is actually not only responsible to the American people to uphold the Constitution, they're responsible to the Congress, and Congress hasn't done a very good job keeping them accountable. And this is why we see the political battle there is today. With that being said, President Trump is absolutely within historical and constitutional bounds to nominate a justice, and the Senate is within those historic and constitutional bounds to approve that nominee, whoever it might be, if that nominee has the credentials they need, which by and large we expect they will. So this is something that, even though it's a very dramatic situation right now, there's a lot of really good historic evidence to find out that this is not a brand new thing. And if you want to know more, you can go to the WallBuilders website. And we have several different resources related to judges and to American history. We want to encourage you, in the midst of the craziness, in the midst of the drama, all that's going on, the first thing we want to do is pray. Pray that God will help everybody involved in the process, that God will help bring to light whatever needs to be brought to light, and then that there's a good resolution of what's going on, because we don't need more division in this nation. We need people that can come together and unite in the process. Part of what allows us to unite is recognizing the fundamental truths of the Constitution.